I'm here with Ian Lamont. He is an associate at Coughlin Gerhart. Now, Ian, you work out of the firm's office in Walton, New York, and your practice is in estate planning, estate administration, and real estate. So today we'll be discussing small estate proceedings. So can you tell us what that is?
Sure. A small estate proceeding is a special court procedure for transferring certain assets after a person dies. Ordinarily, when someone dies, a court needs to appoint a representative to have full control over the assets of the deceased person. This representative has the authority to buy and sell and do virtually anything that the deceased person could have done with his or her own assets during that person's lifetime. Now, generally, if the person died with a will, that representative is called the executor. If they died without a will, that's the administrator. The process for appointing an executor or an administrator can be very lengthy and expensive, which becomes a real burden when the deceased person didn't even have that many assets to begin with. By contrast, the administrator in a small estate proceeding has very limited authority compared to an executor or to an administrator in a regular estate. But the advantage is the process for obtaining that authority is much less expensive and is generally shorter.
Okay, Ian, so how small is small, and who's eligible for a small estate proceeding?
Well, that's a good question. A small estate proceeding is available if the deceased person owned no real estate at the time they died and had assets less than $50,000. Now, determining whether someone qualifies is not quite as simple as adding up the value of the deceased person's bank accounts. Because of the different ways that people can own property, and because certain assets don't actually count toward the $50,000, it can even be quite confusing.
Okay, so can you describe the process for a small estate proceeding?
Sure. The proposed estate administrator, which would be the person who is named in the will as executor, or one of the deceased person's closest family members, that person files an affidavit in surrogate's court. That describes what the assets were and who the beneficiaries are. If there is a will, then that gets filed as well, but it's not subject to the same probate proceeding as usual. In addition to the affidavit, the administrator files a copy of the death certificate, a copy of the paid funeral bill, and a copy of the family tree affidavit. At the end, once everything's been paid and all the beneficiaries have received their inheritances, the administrator provides proof to the court that all of that has been done.
Okay, and can someone apply for a small estate proceeding without an attorney?
Yes, in fact, the court system even provides the necessary forms on their website. That said, it is always best to consult with an attorney first, because as I said before, it can be difficult to determine which assets count toward the $50,000 limit, and it can be difficult to determine whether they even owned real estate at the time they died. Plus, the existence of debts or complicated family dynamics can also play a role in determining whether a small estate proceeding is appropriate. Either way, the trust and estate attorneys here at Coughlin Gerhart have experience with estates of all sizes, and we're always happy to help families navigate whichever proceeding is appropriate in their situation.
Ian, thank you so much. I appreciate it.
Thanks for having me.